This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about how an arsonist and murderer, acting as his own lawyer, failed to get himself out of jail, and why a convicted insurance fraud felon will continue in his new home in the Gray Bar Hotel. Charles Moss, a federal inmate proceeding pro se, acting as his own lawyer, appealed the district court's dismissal of his habeas corpus petition for lack of statutory jurisdiction. In Charles Moss v. D. Jones, acting warden, the United States Court of Appeal for the 10th Circuit on February 21, 2023, gave respect to Mr. Moss as a pro se appellant, but still showed he failed in his attempt to get out of jail. Moss had played a role in a separate insurance fraud scheme that culminated in arson, murder, and the destruction of a van used in the killing. A federal jury in Louisiana convicted Moss of conspiracy to commit mail and wire fraud, use of fire to commit obstruction of justice in relation to the van fire, and use of fire to commit mail fraud in relation to a house fire. Moss appealed, and the Fifth Circuit rejected his arguments. Moss, among other things, then argued actual innocence based on newly discovered evidence and an intervening change in the law. The trial court, the district court, denied the motion. The magistrate judge recommended dismissing the petition for lack of statutory jurisdiction, noting that the so-called savings clause permits a federal prisoner to proceed only when the remedy under the statute is inadequate or ineffective to test the legality of his detention. The magistrate concluded that Moss failed to demonstrate that the remedy available to him in the sentencing court was inadequate or ineffective, and warned Moss about the hazards he faced if he did not promptly respond. Under the 10th Circuit's firm waiver rule, the failure to timely object to a magistrate judge's finding and recommendations waives appellate review of both factual and legal questions. There are two exceptions to the rule when 1. A pro se litigant has not been informed of the time period for objecting and the consequences for failing to object, or when the interests of justice require review. Factors relevant to the second exception include a pro se litigant's effort to comply with the objection requirement, the force and plausibility of the explanation for his failure to comply, and the importance of the issues raised. The first exception does not apply because the magistrate judge informed Moss of the time period for objecting and warned him of the consequences attendant to his failure to object. Regarding the second objection, Moss does not assert he made any effort to comply with the objection requirement or offer any excuse for his failure to make such an effort. He instead argued the court should apply the interests of justice exception to the firm waiver rule because the district court plainly erred in dismissing his habeas corpus petition. The 10th Circuit rejected this argument. Moss failed to meet his burden to show that the remedy provided by the statute was inadequate or ineffective, while he argued that his conviction lacked sufficiency. A showing of actual innocence is irrelevant to the Savings Clause inquiry. Under the 10th Circuit's firm waiver rule, Moss waived any challenge to the magistrate judge's factual findings or legal determinations by failing to object to them and the district court's judgment was affirmed, just as the Fifth Circuit affirmed his original appeal that failed to set aside his conviction. In my opinion, criminals, by definition, have little or no respect for the law. After being convicted of the serious crimes of insurance fraud schemes that resulted in arson and murder, Moss refused to accept the punishment for his vicious crimes and failed in his first appeal, and then filed a habeas corpus action which was given respect it did not deserve, and he is still in jail and has the right to appeal further without even filing a fee, even though he probably has no chance of success. Moss, therefore, continues his criminal activity by abusing the judicial system, requiring it to give respect to his appeals, which really should be ignored and sanctioned. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog posting, and you will receive 5 to 6 blog postings every week. You can also subscribe to the videos at rumble.com or youtube.com, and I'd appreciate it if you watch them, if you would click on the like buttons or on the rumble buttons at rumble.com, and you can subscribe to them. And if you found these blog postings and videos to be of use to you, please tell your friends and colleagues so that they can also subscribe to the blog and to the videos. Thank you for your attention.